Hi everyone. Thank you for joining us. We're gonna start the session like in a minute or two. Hello. Hi everyone. So we have our speaker with us, and let me kickstart the webinar. I hope I'm audible to all of you. Okay. Thank you. All right. So we are discussing today a topic. Your petition is a story, not just a pile of documents. Before we start, I'll just give a background stage. So many extraordinary people, brilliant researchers, innovative founders, creative professionals come to us with incredible achievements, and yet their petitions read like a checklist, a cold transactional, forgettable. And that is where petitions fail at times, not because the person wasn't qualified, but because the story wasn't told properly. And today, I am joined by incredibly talented senior immigration attorney with us. Her name is Nusrat, and we are going to walk you through what it really takes to build a petition that doesn't just meet the criteria but moves the officer reading it. We're talking about the EB-1 and O-1 petitions, how to frame your narrative, how to present your evidence strategically, and how to make sure the person reviewing your file truly understands the weight of what you have accomplished. Whether you are just starting to explore your opinions or you are ready to file, this session is for you. Uh, Nusrat, all yours.
Thank you so much, Swati. I hope you all can hear me okay.
Yes.
Yeah, okay, great. Thank you so much for the kind words and the introduction, and excellent introduction to our talking points today. So yes, I have been an immigration attorney for at least 18 years now, I think approaching 19 years. I am a former USCIS officer as well, not adjudicating EB-1A petitions, but other types of petitions with USCIS. So I have that understanding from the government side of things and how cases are adjudicated, how officers look at evidence, et cetera. So I'm happy to talk about our topic today because it's really important. Of course, I think it will help to, um, you know, build a stronger petition, have you be more effective in how you're doing profile building, and hopefully get you to an approval down the line when you're ready for that. So let me just give me just a moment, and I'm going to share my presentation. Just a moment. Okay, so we're going to talk today again about what the EB-1A is and just a general kind of introduction. You understand that the EB-1A does have a high bar for entry, and excuse me just a moment. I'm a little bit new to, I usually use different format. Here we go. Okay, starting from the beginning. So, the reason why it's all the more important to talk about EB-1A and O-1 and telling your story in an effective way is that we're in a time of, declining approval rates. So, as So as approval rates are dropping a little bit, they're still fairly high, but as they are dropping a little bit, it's important to really stand out as an individual. The gist of the EB-1A category is, it's an Einstein visa, and, it's sometimes referred to as the Einstein visa. So that kind of, even though that's not official USCIS language, it gives you an idea of what you can expect in terms of how, it's viewed, the category is viewed. So it is a special category. It's meant to be preserved for people at the very top of their fields. And our job is to help show how you are at the top of your field. So it has obviously a lot of attractive benefits, including the ability to self-petition, a much more advanced priority date, so not much of a wait. There's no perm process required, so you don't have to go through recruitment and labor certification, everything like that. So, in terms of the benefits, it's really attractive, which is why a lot of people obviously are interested in doing it. The O-1A can be seen as, or the O-1 category can be seen as kind of a younger sibling to the EB-1. The O-1 requires, its own criteria. It's kind of mirrors the language of EB-1A to some extent, but not exactly. So let's see. So as you can see, there are different O-1 subcategories. Most relevant to us in this group will likely be this O-1A. And you can see that it does require extraordinary ability. It requires a level expertise, indicating that the person is one of the small percentages who has risen to the very top of their field of endeavor. Moving forward, you can see that their approval rates for Q3 in 2025, not as high as it used to be. It seems to have a downward trajectory. So we're at 79.7. It's still a high, approval rate. Majority of cases are still getting approved. There are a lot of petitions pending, but you want to be in the percentage, obviously, of the people who are approved, and they do have some commonalities of those petitions. So there are also subcategories of EB-1. So you can see that the actual true EB-1A approval rate is a bit lower than the average given. So it's 66.6% for EB-1A specifically. And it does have a very high bar. These other two categories are for different types of individuals. Outstanding professors and researchers is EB-1B. EB-1C is for multinational managers and executives. It's a great category if you qualify for it. It usually requires an L1 or E2 first, or you have to have something like that type of experience, executive or managerial experience abroad with a qualifying company and then a qualifying company in the US as well. You do have to be petitioned for that. There's no self-petition there. But focusing on, why the bar is higher for EB-1A and why the approval rates, although dropping, are still relatively high, is that a lot of people get weeded out from the EB-1A category because they're just not qualified. So there are things you can certainly do to enhance your qualifications and enhance your chances for approval. But because the documentary requirements are so high, you have to have very specific ways that you meet the various criteria that are outlined in the law. Some people just can't get to that. So, they go for other categories or they just wait for their perm to be approved. And we'll get into that a little bit more. So what we want to focus on in building a strong EB-1A or O-1 petition is to really understand the criteria. So there are a lot of misconceptions about these criteria. The idea is it's like a checklist, and if you meet it, you're good, you're going to get approved. Now, some of this is a little bit in flux right now. The way USCIS adjudicates these cases is that there is a two-step process at this time, and it's called Kazarian because that's just the name of the famous case that kind of outlined this two-step process. But what the officer does is they get this petition and they have a certain turnaround time that they have to create some kind of response. And the turnaround time is faster if you do premium processing, of course, because the officer has to issue some kind of response within 15 business days. And what they want to see is, do you meet step one? Do you meet at least 3 of the 10 criteria that are outlined for EB-1A? And then if you do, great, then you pass on to step two. And in step two, they look at all of your evidence as a whole, and they want to decide, has this person demonstrated by at least what's called a preponderance of the evidence, so more likely than not, have they demonstrated that that they are, in that top percentage of their field, that they have sustained a claim, and that they're really advancing their field and they're going to benefit the United States. And this is where it can be really challenging for people, and this is where it's really important to tell your story in an effective way and present your profile in an effective way. So, letters of recommendation can be a really strong point in demonstrating this and telling your story. There are other ways as well that we'll talk about. Letters of recommendation are letters from experts in your field. They can be people that you have worked with as well, so they can serve multiple purposes. They can verify the experience that you're using to qualify for this category, and they can talk about, your field a little bit and give a little bit of background information, and they help to paint the picture about who you are to the officer. So, it's important to strike a balance here in these letters. So we want the technical side of things kind of explained in lay terms, because you have to remember that these adjudicators are not in your field. They quite likely are not in any kind of STEM field or never have had any exposure personally to STEM other than these petitions and reading these petitions. They're most likely lawyers. And so this is where, a lawyer's expertise is really helpful, because they help to essentially translate your experience and what is special about you for the intended audience, which is the adjudicator, who is not a technical person, but they need to have some understanding of your field, well enough to understand, number one, how important it is to the United States that this field be advanced. And number two, how important you are to the field and how you rank amongst others in your field, and what shows how you rank amongst others in your field. So I will often tell my clients that, you are the best person to tell your story. You're the best person to tell us how the criteria fit into you. So rather than starting with the criteria, start with your own experience and your profile and your background, and let us interpret how the criteria can fit into what you actually do and what actually marks you as special in your field. So in terms of the letters, again, the letters have to be detailed and credible. They have to be from respected people in your field. The way we demonstrate that they're well-known and respected people in your field is, at a bare minimum, you have to have a detailed CV from them. A LinkedIn profile can be used, and nowadays it has become the standard, but it is much preferred to have a detailed CV with, really specific information about what they've worked on, what their accomplishments are. And then, of course, if they're very well known, then you might be able to present some background information, like news articles about them, talks that they did, awards that they've won, things like that really help to enhance the letter writer's profile and therefore your profile as well, because they're talking about how great you are. And then finally, one point that I really want to drive home with the letters is, for a long time, and really according to the adjudication standard, a credible letter should be enough to be evidence, to be considered good evidence. But these days, credible letters are not enough alone, because USCIS is just seeing a lot of petitions, and they really want to make it a tough standard because they see this as a very special category. They want their interpretation of the law is that, the corroborating evidence to support the letters make the letters credible. So any claim that is made by a letter writer, you really should be able to back it up with some objective evidence. And when I say objective evidence, I mean, it just depends on what the letter says, but it could be something like, an internal company award, a financial report from the company, an organizational chart that shows, how unique your position is, or that you're the only person doing that particular type of work. And you're therefore relied on, so you're critical to the company or to a project. These kinds of things are corroborating evidence, and they exist without any input from you. They exist just as a course of business. So they're considered very reliable, because otherwise, you could just create evidence for anything you wanted to show. When USCIS adjudicators see this kind of objective evidence that exists beyond any control or input you have, it really helps to strengthen your case. And again, like I said, create a compelling narrative. That's really important. So one of the big kind of credos with legal writing is we always want to show, not tell. So everything we're saying, it should be backed up by evidence. Legal writing can be very tedious for this reason. You always have a citation after any fact or claim you make. You can't just, say something without backing it up with corroborating evidence, whether that's research from the field or one of the exhibits that we're attaching because that's something you gave us as evidence. Every single statement that we say about you needs to be backed up by evidence, and that helps us to tell your story in a really compelling way. And it makes it really solid in terms of, us being able to demonstrate that you meet your burden of proof, that you are this extraordinary individual. And like I said, we want to educate strategically. We want to explain your field and explain all of the excellent technical work you've done, but we don't want to be overly technical because that is not our audience. Our audience just needs to be able to translate your work and your accomplishments into the criteria, the legal criteria. So we want to be able to show that you're essentially in the top 10 to 15% of your field with whatever evidence we can. And so it's important for you to go back to your experience and think about what have you done in your career that demonstrates that you're in the top percentage of your field. So you can think of your salary, you can think of various projects you were entrusted with that shows the level of responsibility you have within an organization, group memberships and other things like that. Same thing. It has to be very special. It has to show that you're at the top of your field. Every single piece of evidence we have has to keep reinforcing that point to paint this picture of you for the officer and make it really easy for them to issue an approval. They don't want to wade through tons and tons and tons of evidence and a very long brief and everything else. We want to be concise, straight to the point, effective. So keep that in mind as you're, considering these categories. And everything I'm saying about EB-1A, it applies to O-1 as well, for the most part. O-1 has some particular requirements in terms of a petitioner or a sponsor. But yes, we generally want to follow this guidance for O-1 petitions as well. So what happens if things don't go your way? There are options, and a denial, as it said, is not the end. It doesn't count against you. You can always, if you get a RFE that's really aggressive, very long, it looks like the officer is not looking at your evidence at all, perhaps, which happens, unfortunately, then you can always withdraw. You can refile. They're without prejudice for the most part, and I'll tell you what the exceptions are. And so if you resubmit, hopefully you get a new adjudicator. Hopefully you can strengthen your petition before resubmitting. You can see what might be some weak points, and then resubmit. The second option, appeal or sue. Now, this is particularly interesting right now because there has been some litigation relating to EB-1A. Specifically, that two-step process, the Kazarian process that I was describing, that is coming into question a little bit. So without being too technical, essentially, a federal district court has decided that this two-step process is not correct, and it is not a correct interpretation of the law, that the government is going way beyond its authority by, just creating this two-step process that is just, there is nowhere in the law that says this two-step process should exist. And that would be great for everyone applying for EB-1A. The problem is the way case law works and jurisdiction works is that it's a very low-level court that has decided this, and it takes time for these kinds of rulings to go through the court system and become law. Now, sometimes USCIS will adopt a certain policy position based on this lower level court ruling because they can see the trajectory. They can see that they're going to get more and more lawsuits. It's going to cost them a lot. So they want to, avoid that. They reconsider their adjudication standards, or they will fight, which is very common with this administration, and they will push it up through the court system, and they will hold their ground and not change, their adjudication standard. So there is an attorney out there who's filing a lot of these federal lawsuits challenging denials under EB-1A, saying this two-step process is creating an impossible standard to meet, that really the law doesn't allow for this two-step process. It should just look at the criteria and look at the quality of your evidence and see if you're credible. We'll see what happens. For now, the two-step process is still the law of the land, so we'll proceed as if it is. But from a strategic perspective, what attorneys are doing is they're trying to make sure that we can make an argument that you qualify on the whole, whether you look at a two-step process or not. So it means we have to adjust the way we're doing our legal writing based on this ruling. So alternatives, this is where you talk over all possible options with the attorney. You can consider a national interest waiver, which obviously the EB2 category doesn't help a lot in terms of the priority date. It's pretty backlogged, but it is a self-petition, so it does give you freedom in that sense for whatever your priority date does come up. There are also other options if you have the resources to do it, something called EB-5, which you may be familiar with. It's an investment type visa. It requires, depending on how you do it, an investment of, at this time, $800,000 or $1 million plus, usually $800,000. And you have to demonstrate lawful funds and invest in a qualifying project and make at least 10 US jobs within about a 2-year period. So that is a good path to a green card if it's available to you. It's, right now there is a deadline coming up at the end of September. And this deadline is, pretty fast approaching, but we're still taking EB-5 cases as well. So if you've worked for a company for a long time and have RSUs or other means to get the 800,000, it's certainly an option as well. So, that's essentially the gist of where we are with EB-1 and O-1. So strong documentation, quality evidence is really important, and a compelling narrative, is what separates approvals from denials. Really understanding the criteria is important, understanding that each of the criteria may look somewhat simple to you, but it has all of these different elements that have to be individually met. So, same goes for the letters. A letter of recommendation, it needs to be very specific. It has to have certain language in it that points to the EB-1A criteria and qualifications. And that's what a good attorney works with you on, is to make sure that all of those fine details are being met and satisfied. Okay, so with that said, I'm happy to take your lead, Swati. I think we're ready for questions and answers.
Yes. Thank you so much, Nusrat. It was very insightful, and the process is very clear. I hope everybody would understand how to step ahead and how to walk layer by layer in preparing their EB-1 and O-1A. We have Josh who has asked his question, so I'll say this. So he's saying that he's an Indian passport holder and he has an EB-1A approval with a priority date of June 5th, 2025. Currently, the April visa bulletin is 2020. In 2026 shows the filing date chat at December 1st, 2023 for Indian, and final action date chat at April 1st, 2023 for India. The intention is to continue to adjudicate with the filing date chart. He has applied for EB-1A after working in Los Angeles while on an O-1B before the pandemic. and he's currently debating whether he should consider renewing his O-1B. Should it be feasible and or move back to Los Angeles to wait it out as the visa bulletin gets updated and uh, moves past June 5th, 2025 to allow him to file his I-485. So it's a bit long question, Nusrat. One more para in that. And later he's asking, is this a wise choice for a bridge? Should he wait it out till after the midterms in 2026 to see possible further forward movement in the dates? Is there a chance for enough push forward with the dates to get further ahead by the end of the fiscal year and the start of the next around and after October 2026 and November 2026 visa bulletin?
Okay, thank you, Safi. So I should start by saying that I cannot give any personalized legal advice in this forum. It's intended just for general questions. For you have great questions for sure. It's best to discuss those with an attorney, and I'm happy to consult with you if you like. There are, you're demonstrating like really important points with your question, which is you have to consider strategically how to file an adjustment status, when to file an adjustment status, how visa bulletin dates advance. In terms of, you know, uh, visa bulletin prediction, that's always a little bit of, unknown there, especially with this administration and the very kind of drastic and rapid changes that happen very quickly, like restrictions on entry and other visa categories and how that might advance, certain employment-based categories, especially for people that are not subject to the restrictions. There's a lot of speculation that there will be like more advancement for India because it's not on those restriction lists right now. So great questions. Good to consider your timeline. Good to understand, how O-1 and EB-1A can work together. A little bit of background that might give you some useful information is that, once an adjustment of, so basically, what an EB-1A is a petition is approved. That's an I-140. And so that is the basis of a green card application when your turn comes up on the visa bulletin. So the green card can be obtained in one of two ways. You can either stay in the United States if you're already here in the right kind of status at the right time, and you can file the application from within the US. The benefits of that are you get a work permit and a travel permit if you need one. Work permit these days, it is taking much longer than it used to, but maybe at the 6 to 10 month mark, you get a work permit and it allows for free and unrestricted work. That said, most attorneys will advise you to continue to maintain some underlying status instead of starting to use that green card related work permit. Because once you use that, you're no longer in any other status. You're just relying on your pending green card application. And then eventually, when the visa bulletin is current according to final action, when the visa is actually available, that's when your green card can be approved. It takes time for that to happen. And in the meantime, if you're in O-1 status or even your O-1 lapses, you can't travel until you get your travel permit. And, you're not in a green card status yet. You have to get that green card application approved, and then you're in green card status. Now, this other way to get your green card is through consular processing. When the I-140 petition gets approved, USCIS sends it to initially a clearinghouse, essentially, that gathers your documents. And then they will approve, say that your documents are good. And then they'll hold on to your file until the consulate in your home country is ready to schedule you for an interview. So once you're scheduled for an interview, that happens when the consulate has interview slots available. You have your interview in person. You have a quick interview. Hopefully you get a visa stamped in your passport. You have 6 months to enter the US. The moment you enter the US, you have your green card. So, the benefit of being an O-1 and doing consular processing is that you have freedom to travel. You can keep renewing your O-1. The downside is, of course, you're at the mercy of this consulate abroad, and consulates tend to be more volatile and there are fewer avenues for review. So hopefully that gives you a little bit of background information that might help you, but do schedule a consultation one-on-one with an attorney. I'm happy to talk with you if you'd like to get in touch.
Yes. So, Josh, I have already shared Nusrat's email ID, so you can write her an email, or you can go to the website and book a consultation with her, and that would be the ideal way to understand the situation. And Nusrat, there is another audience of ours who's asking about the high remuneration. So Muru is asking, could you share your thoughts on how the high salary criterion will be determined? If the current salary is at par with the prevailing wage level 90th percentile start range, would that be sufficient to satisfy the salary criteria?
Yeah, so prevailing wage. When you say prevailing wage 90th percentile, those are kind of a few different things. So I'll say generally that USCIS has been rejecting high salary arguments based on Department of Labor data alone. So a good approach is to have a few different sources demonstrating what the salary is for your specific profession, what you're arguing your area of expertise is, what you've been doing. So there are a number of different sources aside from the Department of Labor. I mean, you can have like broad, open salary surveys, payscale.com, these kinds of things, or you can do something more specific and academic, like a Radford salary survey. So prevailing wage is one argument you can use, like a wage level. You can also use the Department of Labor statistics that show the bell curve and show that you're in the 90% plus range. But the legal argument is overall, and there's a memo that says this, a USCIS memo, specifically for the Nebraska Service Center, but it's informative that, the reason why I mentioned that 10 to 15% range of being at the top of your field is because that's the idea. You don't have to be in the top 1% of your field. You have to be in the top 10 to 15% of your field to qualify for EB-1A. So translating that to high salary is that you should have a high salary in your profession compared with others in your field. I believe that being in the 90th percentile should qualify for high salary. If USCIS pushes back on it, there's a very good legal argument for that. And there are different types of compensation that you can include. You don't have to just focus on your base salary. Certain types can't be included, but there's a whole list of types of compensation and variable compensation, incentive-based compensation, RSUs, things like that that can be used. I typically always use RSUs. I make an argument just in base salary, then with other elements added to compare with what other people's compensation in the field is.
Okay. Thank you, Nusrat. Anybody else has any questions? No? If you guys have any questions, you can unmute yourself and also ask.
Sure. Hi, Nusrat, and my name is Saroj. I have a question. Suppose I'd like to go out for EB-1A. So, how you guys are going to help us? Like, you help in creating the entire, profile evaluation till the filing of the case.
So the way we work with a client or a potential client is that we start with an initial screening to understand what your qualifications are, what your background is, and we want to see how you can demonstrate that you're at the top of your field. Now, typically, if you have some strong elements but not others, we can give you some general direction about what you can do to perhaps enhance your chances, your profile essentially to get to an approval. So, there are certain things that you might be able to control, but there are certain things that just are beyond your control, and it's just a matter of career development and time that will allow you to kind of get to that threshold of being approvable. So we do a very thorough assessment of your qualifications and your background. And we tell you what our opinion are as to your chances of approval as it stands today, and then consider certain elements that you might be able to work on, like try to look for good prestigious speaking engagement, get involved in judging activities, things like that. Just to, it's essentially kind of career building, but it also enhances your profile in such a way that it makes you more eligible for EB-1A than you would be without that experience.
Okay. I have assumed like 21 years of IT experience with Bachelor of Engineering in Electronics and Telecommunication, MBA in Finance, and specialized field earlier into like investment banking, that is for foreign exchange, money market, derivative. But last 15 years, almost 15 years into e-commerce, digital transformation, and the business transformation side, with the current position as director, and salary is okay, the way it
You
falls into
don't
the category.
actually.
So
I'm
my
going to stop you because
question is it enough for you to evaluate my case, build my profile, present to the attorney? So if I understood correctly, EB-1A have two sections. One is building the profile. Okay. Second part is, okay, the attorney will file it. So building the profile, education, position, prior experience, and salary part. Okay, out of the 10 criteria, suppose I fulfill 4 or 5 or 6, then other things are like certification, recommendation letter, that okay, I'll bring it. But judging, I heard some IEEE things that you have to do some
Um,
presentation. Who is
Saroj,
going to do?
Saroj, I have to stop you out here because this is a very technical question and it needs a lot of background check. So this is not a right platform to like answer this specific question. You can
Okay.
like email me at swati@visaarchitect.com. I'll evaluate you. We'll understand where you stand and where your profile stands. If it's all
Mhm.
set and we can file, we'll definitely gonna file. If there are any gaps that we see, we are more than happy to like polish it, understand it, and then move ahead for the filing stage, right?
Got
But
it.
yeah,
Thank you.
just see the chat box. I have given you a process as well as my email ID. Please drop me an email. I'll definitely go and set up a call and then we can take this. It's a
Okay.
descriptive call and it will take a lot of
I
eye
understand.
and
Yeah. Thank you
understanding.
very much. Yeah.
Thank you.
absolutely. And I don't want you to give your, personal information. We have a big
Yeah.
call and this is being recorded. So,
Yes.
just be
I
mindful of
understand.
that. But yeah, but just generally know, like Swati says, it starts with an evaluation, understanding your background. It sounds
Mhm.
like you're pretty advanced in your career, so you could very well qualify, but it's all individualized and you have to have a one-on-one consultation.
Thank you very much. Yeah, I understand. Yeah.
Mhm.
Yes.
Of
Thank you.
course.
We have some more questions, Nusrat. Mazhar is asking, do patents help if they are not being put in use yet but have potential?
Yeah, so patents, the way patents are usually used is for original contributions. But like I said during our talk, each criteria has all of these different elements that you have to consider to see if the evidence that you have is helpful or not, or if it meets the criteria or not. So the original contributions criterion requires that the work be original. So a patented project, technical advancement, whatever. Certainly, you can demonstrate that it's original because you have a patent, right? That's the whole point of getting a patent. But you have to also show a significant impact on the field. And that's where the use of a patent helps. So the impact really has to be significant and important. You have to be able to demonstrate it. How you define what is significant for your field, that can be something that we use your story to educate the officer on, if you have the evidence to back that up, right? So if one company is going to use it or is interested in it, or they have a very clear plan to use it, then perhaps we can make an argument. But otherwise, typically, I will say that you should have widespread use or commercialization of a patent for it to count as original contribution. Otherwise, depending on what it is and what the interest in the patent is, we may be able to use it just to kind of either maybe comparable evidence or to enhance, the second step of the Kazarian analysis of, looking at your evidence as a whole, looking at your profile as a whole, and showing that you're in the top percentage of your field.
Okay. Another question we have, Nusrat, from Navneet, I believe, Naveen or Navneet. What are some common red flags for USCIS to issue RFE, NOID, or denials? Insufficiency of profile is understood, but what are the other things that catches their eye?
Yeah, so, let's see. So there are a few different things. I mean, for example, only relying on the Department of Labor data for making a high salary argument. In terms of red flags, just, insufficiency of profile, yes, but also not taking the time to highlight each and every element of each of the criteria. So let's say group membership, for example. I heard someone, I think, Suraj, maybe you mentioned IEEE. So, obviously, as we submit these petitions and we see common memberships amongst different people, we can also see adjudication trends and we can see how USCIS views certain types of memberships and things like that. The membership criterion, for example, has become really, really difficult to meet. So one of the reasons is that they claim that something like IEEE senior membership doesn't meet their criteria. I think there's an argument you can make that it does meet the criteria, but the way they've interpreted it is that it doesn't meet the criteria because it doesn't require outstanding achievement or all these alternative ways to qualify. And, the people judging you for admission maybe aren't experts in their field. So those are all the different elements of the membership criteria. And that's what's really important in terms of, presenting a good approvable petition in the first place, is making sure that you hit each of the criteria and just not throwing everything in. In my opinion, a red flag is an overly long petition that just has all of this stuff in it, and some of it is just not good enough. It's better, in my opinion, to focus on quality evidence that we know is going to meet the criteria. We have very good arguments that those pieces of evidence or those elements meet the criteria, the law. And we have some additional evidence that we can hold on to because the rate of RFEs is very high. And that way we do have something to respond with as well if an RFE is issued. So we can tell you, generally, like, hey, when we look at your profile, like you have these things, they might qualify, but most likely USCIS isn't going to accept it. And it doesn't mean that, it's not a mark of how good you are. It just means that it may not be considered to meet the very specific criteria that USCIS is looking for that particular criteria. It most often comes up with group memberships, but it comes up with other things as well, like judging sometimes it comes up with.
Right. In continuation with that, he's again asking Nusrat, and red profile building, reg profile building, does recency of evidence works against the application? How does the officer see windows of judging publication, original contribution, 6 months versus 1 year versus 1.5 years? What is an ideal spot? Sometimes with given latest trends with AI developments, we might only have the time or opportunity to shine recently.
Yeah, these are excellent points that you're bringing up. So I'm very glad you asked that. Recency of evidence can work against a person in two ways. On the one hand, it may reflect poorly on a person's credibility, where the adjudicator looks at this and they say, well, all of this is in the last year or last 6 months or something. It looks like you're just doing this for purposes of filing an EB-1A petition, which is kind of a catch-22 because, working on one's profile isn't something new. It's something that's always been done in some capacity in EB-1A. So it's kind of an unfair conclusion that they're coming up with. But they often don't come at it directly. They will say, well, the evidence is very recent. In the adjudicator's mind, they may think this person isn't credible, but then they'll say, well, it doesn't mean sustained a claim. But that's incorrect because sustained acclaim can mean a lot of different things. It's open to interpretation. And as you're saying, especially in a field like AI, um, you know, recency is where it's going to be because it's a very new, fast evolving field. And how else are you going to show development? So it just, it's important to definitely look at your whole career and make sure that you're mining information from your background that shows how good you are and you've been good for a long time that meets the qualifications. But also, this is where storytelling is really important. We want to give background about your field. We want to show what is typical for your field in terms of showing how good you are. And, you know, it's not like, where this kind of has been an issue historically is, if a person is a rising star, like an actor, and they want to file an EB-1A, they're not qualified for EB-1A. Even if they had one, really good role and they had some press about them recently, that's typically like what the older kind of case law relating to this element of a profile relates to is that, oh, just because they were in one movie, that doesn't mean that they have sustained a claim. They have to show that they're consistently good, especially in something like entertainment where things can change quickly. So translating it to this other kind of field, there are different ways to show sustained acclaim. And if you can help us to tell your story in a good way, to explain what your profession is, explain what your area of specialty is and how quickly it moves and what the appropriate time scale to judge it is, that will help to overcome that presumption of perhaps in the background, a lack of credibility, but what they directly say is not showing sustained acclaim.
Okay. Anybody else has any questions? Deepak Reddy is asking, how can we build profile over time for an industry expert who doesn't have any publications, patents, or judging? Does building something on the above for long-term help and how to get started?
Yeah, so you don't have to have publications, patents, or judging per se. You have to start with a point of showing that you're at the top of your field and help us, find the evidence in your background to support your case. So, like I said early on in the presentation, it's not just about meeting this checklist of the criteria and then suddenly you get an approval. The whole point of the EB-1A category is to demonstrate that you're at the top of your field, the top 10 to 15%, and everything that you work on in your profile, in your career advancement, etc. You want to have it show that you're in the top 10 to 15% of your field. EB-1A only requires that you meet at least 3 criteria, right? And you can't even win on 3 criteria if you have good, strong quality evidence. I don't recommend, for example, just trying to publish anything anywhere if that's not something that's normal for your field. If you're, someone who is in a real world field and the way you demonstrate excellence in your field is with certain markers in your career, and then you suddenly are like pivoting and publishing a bunch of scholarly articles in journals that don't have a good reputation, it's not really going to help you. And in fact, that can be a little bit of a red flag where, well, why is this person throwing all this evidence and that has nothing to do with their field? So you have to be very thoughtful about, the way you develop your career and your profile. And it has to always support the main point, which is that you're at the top 10 to 15% of your field, of your profession, and that all of your evidence reinforces that. So you don't have any publications and you have moderate kind of demonstration of you being at the top of your field, well, look into professional publications for your field. What is relevant to your field? Speaking engagements at conferences that are important to other people in your field, that are hard to get or are rare. Not everyone is doing them. Those kinds of things do help, but of course, you have to be very thoughtful about it. Don't just, do any kind of hackathon judging and think it's going to help you because it probably won't. It has to be very thoughtfully done.
Right. Nusrat, there is another question by Sarjan. He's saying that will a significance contribution at any NGO will fulfill one of the criteria for O1? He's from technical background and will be providing support by building a AI-powered SaaS platform to NGO.
Sure, it certainly can. We just have to look at the details in a consultation. But, I mean, it may, especially depending on what the NGO is doing, that can really help in terms of the quality of the evidence and showing a positive impact, especially if it's US based, or has an impact in the US in terms of like US welfare, public benefit, et cetera. So you can kind of hit a few different elements with that. And that actually brings me to another point I wanted to make is that, like I said, important to look at what you're working on because it might not just be one element. It might meet several criteria with the right interpretation of that evidence. So you're building this for this NGO. It might be an original contribution with significant impact. You might also be showing that you've played a critical role for that NGO and that the NGO has a good reputation. It has a distinction in its field. And then it's also hitting potentially a final merits kind of argument of demonstrating benefit to the United States in the future, advancing your field, helping US workers or the US economy, et cetera. So that kind of thing is very useful potentially for meeting several of the criteria and just overall approval chances.
Thank you, Nusrat. I think we have one more question. Yes. If I may add another question, how many letters of recommendation are needed if the petition is critical role and original contribution heavy? And on a lighter note, how can I ask my SVP or senior directors for their CV for this purpose? Is their CV absolutely needed?
Yeah, absolutely. Great question. So there's no magic number with letters of recommendation, but what's really important is that the letters are effective. I think that you really shouldn't have more than 5 letters unless, you have an unusual case. For the most part, like I said, we want to be concise. We want to hit the points strongly. We want to make it really easy for the officer to understand the information and to approve your petition. So it really depends on your experience, but most of the time you just want to be concise. Always think of it that way. And let's see. And again, to my point earlier, letters of recommendation traditionally were really good and they should be helpful for a critical role and original contributions. But these days, USCIS really wants the corroborating evidence. So not focusing too much on too many letters, getting that corroborating evidence. And then on the note of the CV, I know it's tough. Perhaps you can ask them if they don't have it, it's okay. We can work with a LinkedIn profile, but I would suggest giving the attorney some other evidence of that person's background to show their position in the field. Some other evidence that shows how good they are and how important they are, what their stature is. Because, we're lawyers. We're not in your field. You know what is good in your field. You have to tell us and show us. So let's say that they have I don't know, a really strong LinkedIn presence, or they've done speaking engagements at really prestigious, events. These are the kinds of things you can give us to help bolster that person's reputation and demonstrate that they're an expert in your field. In terms of asking for a CV, just with a signature, perhaps you can ask them to provide it if they have it.
Absolutely. And so if I may add a follow-up, please, instead of a long chat, because you mentioned recommenders from your same field, right? Can they be from somebody diagonal, for example, a customer, right? Say, for example, somebody is a project or a product manager, a lead from a marketing team, right? Or from a revenue or a finance team who sees the landed impact, which is not directly the field, but like a high position person who's seeing the impact of this role. Can letters of recommenders come from them, or it has to be from people who can comment on the nuances of your skill?
Yeah, so a letter like that can be really good as corroborating evidence, demonstrating that and verifying that you did the thing that we're saying that you did and talking about the impact. as long as, it should be at least related to your field, but if they have that firsthand knowledge, that's really important. Sometimes I have seen a little bit of a trend of people trying to get an independent letter writer that they have no connection with whatsoever, or might just be a friend. And they say, oh, I know about this person because I read one of their articles or something like that. That tends not to be very effective, but someone that's actually worked with you on a project and is in a related field and at least can testify to the veracity of the claims made about the work you did and how it impacted their organization or your customers, that is helpful in my opinion.
Okay, as long as it's legit and within a large organization with a connection between the person who is delivering the work versus who's seeing the fruits of $1 million or $1 billion impact would help, right?
Yes, exactly. And in that case, it becomes more corroborating evidence to demonstrate, the original contribution of critical role rather than just an expert letter. We can try to classify it as an expert letter as well. USCIS can potentially challenge it on that ground, but it's also this other type of testimonial letter that's corroborating other claims.
Thank you. Thank you, Nusrat. Thank you, Swati.
Mm-hmm.
Okay, I think we are all done with the questions, and I will say my closing lines before we go. Okay, so thank you so much, Nusrat, for being here. And we covered a lot of ground today in terms of distinction between EB-101 and the adjudications, how they really look into it, how to build a petition that tells you a story with strength and evidence. And thank you so much for walking us through how it likely more qualified than what we think for our petitions. The biggest barrier we see isn't the eligibility, but yeah, it's the people not knowing how to articulate their own story and extraordinary abilities. Thank you so much for being with us. I hope to have another session with you, and we all will be joining you very soon. Thank you so much once again.
Thank you so much, everyone.
Thank you. Yes. Bye-bye.